Hello everyone, I'm Mark Halsey. I'm here with Fiona Halsey and we are Halsey Legal Services. We are currently doing presentations which are our 6-monthly update of AFCA cases relating to life insurance, and this is the second of our third presentation relating to those matters. It's an action-packed presentation. We're looking at three issues that have cropped up in AFCA Determinations relating to life insurance. The first one is the so-called fence-sitting insurer. In other words, where a claim lodges with an insurer and the insurer takes excessive time to make a decision as to whether they're going to go on claim or not. The second issue we're going to look at is the issue of how definitions within life insurance policies, particularly as they relate to triggers and claims, whether those are or should be updated from time to time based on the passage of time. In other words, do they change after the policy has been taken out with a fresh set of eyes in the future when the claim is made? And lastly, a very, very interesting one relating to level premium insurance, and that is, can the price, the premium of level premium insurance vary over time? So in respect to those, Fiona, if you can kick off in respect of the fence-sitting insurer.
Well, indeed. And anybody who's worked in insurance would know that this is an issue, the fence-sitting insurer. And it's always a difficult point because you would like a decision to be made, but you're always hesitant. Well, you're often hesitant to push too much because you're always thinking, if I push too much, I might get a no, or otherwise I might get a yes. So
the easiest answer is no.
Well, that's it. You never quite know.
No.
But these two cases are really helpful in that they go through and they set out AFCA's view on how claims should be managed within an insurer. And that in itself adds to the knowledge within this space. So in the first case, it involved, and both cases involve TPD claims. And that's not surprising because it's typically the TPD claims which are the hardest to get paid. So an insurer will often pay an income protection policy claim relatively easily because they take the view that they can always switch off the tap later. And they'll pay a death policy frequently because there's a lot less debate about it, isn't there?
Yeah,
I mean,
sure.
you're either dead or you're not generally.
Yes. So
it's much simpler into whether particular events have occurred. I mean, there can be more complexity in terms of underlying conditions and court, that kind of thing. But on the whole, it's a simpler process. So in this case, the claim was lodged on the 24th of February 2020, and it was paid on the 10th of March 2021, so almost 13 months. The complainant said that he should have been paid interest from the 24th of May 2020, so 3 months or 90 days after the claim was lodged with the insurer, because he said this allowed the insurer a reasonable time to investigate the claim. He requested interest from the insurer in respect of that, and a person, a policyholder can be entitled to interest under Section 57 of the Insurance Contracts Act. But in this case, the insurer refused that payment, and as a result, the complainant went to AFCA. AFCA, I feel that the most interesting part of this decision is actually AFCA considered the test, and it didn't deter. Its question was it reasonable or not, but its question was, when did the insurer have enough evidence to admit the TPD claim? And it decided that the insurer had sufficient evidence by the 2nd of June 2020.
Right.
Okay, so not long after the 3 months. What was especially interesting, though, is that AFCA went through the steps the insurer took and determined what it thought was adequate information, and determined when it thought it had sufficient, and also how the steps should have been done. So when you are dealing with a claim, particularly a TPD claim, it often feels like it's just months and months with the insurer. It feels like often feels like they're doing very little. And in this case, AFCA looked at it and said, well, actually, there were steps that needed to be taken. It was reasonable that those steps be taken, But these, for example, should have been done simultaneously.
Mm-hmm.
So they looked, and as an example, they looked at, so they asked the policyholder to complete an education and employment questionnaire, okay, to determine what they're able to do.
In respect of the insured.
Exactly, yes. And then they requested the treating doctor's reports and obtained an employability assessment. Okay. AFCA said that instead of those things being done one after another, they should have done simultaneously.
Makes sense.
Okay. And they looked pretty hard at a policy, at the internal policy of the and saying that this is how an insurer should be doing things. Okay. And giving these really very specific ideas about how a claim like that would be managed. And if you were to, the one thing that I thought could potentially be an issue could be if you are seeking reports from specialist medical practitioners. Okay, and in my experience, they're very slow. However, the AFCA did refer to the timeframes under the Life Insurance Code of Practice.
Right.
Okay, and they are very. There are some quite specific timeframes under that code, and there we have two cases, and the AFCA referred to slightly different provisions of the code and different timeframes in each of the two cases.
Right.
But in the first case, they referred to clause 8.15, which said that once the insurer has all of the necessary information, they should inform the complainant of the position within 10 business days.
Right.
But they didn't take the position, which I think quite a lot of insurers do, which is, well, we don't have all the information yet. Instead, they go back, AFCA went back to the concept of process that we were talking about earlier. It said, well, if you had done things in the way they should have been done, then you would have had the information by this day, okay, which was different. And then they referred to clause 8.17 of the code, which says that the insurer will inform the complainant of the decision within 6 months of the claim being lodged or the end of any waiting period. So they looked at that quite small period of time. But then there's a further case which actually involved both an income protection claim and TPD claim together. And it was handed down in around the same period of time. And in this case, the income protection claim was lodged in October 2019. The TPD claim was lodged in February 2020. And the determination to reject them was in December 2021. So slightly more than 2 years for the IP claim, which in itself is actually pretty unusual because IP is normally fast. But in this case, AFCA noted that the Life Insurance Code of Practice said that an IP claim should be decided within 2 months of lodgement.
Makes sense. It's a replacement income. You can't wait for 2 years.
Yeah, that does make sense, yes. And then referred to, the 6 month period in the early case. But also, there is a particular provision within the code which says that in unexpected circumstances, it can take up to 12 months.
Yep.
Okay.
Yep.
But they found that even in this case, even if there were unexpected circumstances, it was still twice that. So that was not acceptable. And I thought that it is useful to be able to know what the requirements are on an insurer in this kind of situation. Okay, and that they can't just take things on at the very leisurely process that they might like to.
Sure.
In fact, they are expected to be working on this. And if you looked at their timeframes, which were discussed in the first case, they were frequently relatively short timeframes. So there were 2 weeks to get somebody to write a report, and then 1 week to consider the report. It wasn't the timeframes that many insurers take. But now, just moving on to 2 smaller cases, but still significant. And there's been some discussion in the media in respect of often trauma or critical illness cases where the definitions are being held to be outdated now.
Yep.
So that they are defining, for example, they might say heart attack, and then they define heart attack in a particular way. And that might be the way that heart attacks were defined in 2005, but not the way that they're defined now. And there's been discussion about that in the media. But there was a case here where the complainant to AFCA argued that they should effectively have updated the definition. And this case, it was an interesting case in that the policy had made its way between several insurers. So you know how insurers can sell policies around. I think this one had been to 3 or 4 insurers.
Okay.
And as part of that process, it had been through a number of insurers, all of whom had had more generous definitions. Okay, but nowhere, but you know, as we've discussed in our earlier segment today, it's the policy, isn't it? It's a contract, and the terms of that contract are what they are. So the fact that it's been
Presumably the premiums reflect the risk.
well, you'd think that would be the case, and certainly that's how the actuaries work it out, isn't it? They do work it out on that basis. But there has been a feeling amongst some consumers that position might be changing, but it's not within AFCA.
No. Okay.
And then the final one that I'd just like to bring as just a kind of update point is that there's often cases in AFCA with people complaining about insurance premium rises. Happens continually, and AFCA, normally gives it relatively short treatment. But in this case, it was a case involving level premium, and there's often a feeling amongst insureds that if you buy a level premium policy, your premiums will be level, okay, and that they won't increase over time. But in fact, that's not necessarily the case. In most cases, it's simply a case that there won't be an age-related increase. So in this case, the policyholder complained that their premiums had gone up, but the insurer said, well, that's because everybody's premiums have gone up. It's not because you've got older.
Yes.
And as a result, we're increasing this. And AFCA said that was okay. Now, I just mention here, we've discussed whether or not we will give out the name of the insurers on YouTube, and we've decided generally we won't. But we also understand the importance of our clients who are writing insurance understanding the approaches taken by various insurers.
Deciding their approved product list and things like that.
Yes, it's important because really, what happens at claim time is important, isn't it?
Yeah.
And so as a result, we won't be putting the details on YouTube. However, if you're one of our existing clients and you'd like to know, please give us a call. And we can share that information with you then. Thank you for joining us today. And we hope that you enjoy this video and the others in the series.
Yeah, bye now.
Okay, bye.